I see some people coming in, joining us in from Australia, Botswana, Nigeria. Wow, Brazil, South Africa, Germany, Uganda, India, Switzerland. More people from Uganda, India. Oh, this is such a great turnout. And it's so exciting to see all of these flags. Just a reminder to please mute yourselves as you join in. We have enabled you the opportunity to have access to your mics working, but it's only so that this is a fruitful exercise on both our parts. Okay. There we go. I see more people joining in. Ethiopia, the United Kingdom. We've got Egypt. We've got Kenya in the house. We've got the Philippines in the house. Bangladesh is in the house. Argentina is also in the house. I see that there's a message here that you can't hear. I'll ask that you rejoin the meeting and see if that works on your end. If not, please feel free to just reach out to me again. I see Japan is also in the house. Welcome to everyone, and thank you all so much for joining in promptly and on time. We have got a jam-packed program waiting for us this afternoon. We want to try and make it as interesting and as interactive as possible. Some few housekeeping rules. First of all, my name is Mati Komborera Nyamadzi. If you are one of the Moot alumni, you will recognize my name or recognize my face, and I'll be your moderator for this afternoon. Again, thank you so much for joining us and for making this a success really by your attendance already. I am joined today with some seasoned and excellent academic and legal writers who are not only leading authors in their fields, but they're also seasoned mooting judges. So you are in the presence of greatness, and you will definitely be able to gain and develop from the knowledge that will be shared this afternoon. Some housekeeping rules. Please be reminded to always make sure that you check that your mic is muted. You will not be required to have your video on during the meeting. And we will also try and mute Brian and Craig. Just a reminder for you to mute yourselves. And I also ask that you post your questions in the Q&A function that is on your screen. If you're joining from your phone, you'll find it in the top bar. If you're joining from your laptop or tablet, you'll find it in the bottom bar. There you'll be able to pose your questions to. And once you've posed this question, everyone else will also be able to access this question. We're just going to work on muting everyone now, and then we'll get started. First speaking will be Michael, who is both a seasoned judge in both the World Moot and the African Moot, and Michael followed by Juliana, who will be giving us just a brief intro on understanding the African Moot as well as the World Moot as sister entities, but also as individual entities and the things that are different between the two moots. So Simpiwe, if you give me a thumbs up that we've sorted the muting issue, I'll invite Michael to take the floor.
Hi, Matthias. Everyone else is now muted. And if I need to reiterate this, if you are going to cause disturbances, we are going to place you in the waiting room and readmit you. because it's the only way we can at the moment. Thank you so much.
Yes, thank you so much. All right, Michael, over to you and let's get started.
Thank you, Mati, and greetings, colleagues. Good morning, good afternoon, good evening, depending on where you're joining us today. I was given a brief task to introduce the African Moot and to share some of the expectations when it comes to writing a memorial for the African Moot. As most of you will be aware by now, the African Moot is 32 years old this year. It's been going on since 1992, initially as a mooting before a hypothetical African court, because when the moot started in 1992, the African court actually did not exist. As a matter of fact, there was no protocol establishing the court. The protocol itself was only adopted in 1998. You may be right in saying, well, whoever originated the moot or brought up the idea was sort of dreaming about a future African court, which eventually came into existence in 98 when the protocol was adopted and physically established in 2006 when the court was actually physically in place. So the whole essence of the moot, the African moot, now the Christof Heyns African Human Rights Moot Court competition, named after one of the originators of the moot, is to create awareness about the African human rights system, the African Charter and the institutions that have been established by the African Union to promote, protect, and fulfill human rights on the continent. And therefore, there is that motivation to create awareness about the African human rights system, especially among young students who are in the process of becoming lawyers. And the essence of the moot is to sort of whip up a bit of enthusiasm students, but also use that as an opportunity to interact with other professionals, judges, lawyers, and civil society across the continent. And it is one of the reasons why the moot is co-hosted across the continent every year. Every year there is a process of universities bidding to host the moot across the continent for human rights. We sort of move from one country to the other, bringing the message of the African rights system much closer to the African people, and hoping that more and more people on the African continent will hear about the African human rights system, but more importantly, will become familiar with the African court, its mandates, its jurisdiction, and the kind of dispute that it is capable of resolving, and how exactly individuals, civil society, and other organizations who interact with the African court. So it's essentially, unlike other moots that focuses on a hypothetical judicial body, the African moot is specifically based on an already existing court. So the expectation is that a lot of the attention writing, but also in the oral rounds, will be focused on the African court itself, its jurisprudence, and the kind of procedures and practices that are available before the African court. So it's essential that anyone who is participating in the moot pays sufficient attention to the African court. Of course, the problem question would direct you to what kind of legal material instruments are required of you to pay attention to. But the essence of this whole process is to make sure that you understand the African human rights system in sufficient detail, and are able to navigate around all the processes, whether you are appearing as an applicant or you are appearing as the respondent. And that's why as part of, you are required to draft memorials for both sides of the divide, first as an applicant and then subsequently as a respondent, because your role as a lawyer in the future would not necessarily be as an applicant. You could also find yourself hearing a bit of feedback. Can Winter, please, can you mute yourself so that we can proceed with the presentation? Yeah, so as I was mentioning, the essence of this is to make sure that you actually get to familiarize yourself with the court. But because the African Commission is a predecessor institution of the court, a lot of the resources that you would be relying on would also be from the African Commission, because the Commission has, set up precedents over the years since its establishment in 1986. And there is still feedback. Simply, is it possible to mute everyone who is not supposed to be speaking now? Yeah, no, I will just continue and wrap this up quickly so we can have other presentations. So you need to pay really good attention to the African human rights system. Of course, you are required to also familiarize yourself with the Inter-American system, the European system, and the UN treaty bodies generally, as a means of, well, if one was to go to Article 60 of the African Charter, you are required to utilize these as inspiration whilst you're making arguments before the African Court or the Commission or any of the African human rights mechanisms. So it requires you to have a general knowledge of human rights broadly, but very specific knowledge on the African Court and the other mechanisms that are available within the African Union as a political entity. As a competition, it is only open to undergraduate students. We will hear briefly about the World Moot and how that is quite different from the African Moot. If you have already completed a degree in law, you are not allowed to be a competitor in the African human rights system, because the idea is to introduce undergraduate law students. Am I the only one who's getting feedback?
No, you're not. I just put him in the waiting room. It's Winter. Sorry, Michael.
Okay, no, that's fine. So it's only open to undergraduate students who are still in university at this point in time, and it is a once-off competition. So if you have already competed before, you are not eligible to compete again. So if you participated in the competition last year as a participant or a previous year, you would not qualify to compete again, because the idea is also to allow other people to have the opportunity to participate in the Moot and to enrich their own knowledge and skills and experience about the African human rights system as well. So this year we will be hosted by the Kwame Nkrumah University of Science and Technology, which is my own alma mater. About 20 years ago, I was an undergraduate student there, and happy to be going back, after a very long time. And hopefully we will see a number of you in Kumasi to, explore arguments on the African Court, but human rights broadly across the continent and beyond. Well, in terms of the memorial itself, over the years, in the process of, there used to be a free range where we essentially write as much as they wanted to, but the experience taught us that if you give people the free range, they would write so much information that it is almost impossible to mark all the memorials within a reasonable time. So I think this year the rules require that your memorial should not exceed 5,000 words, and if you exceed that number of words, then there might be some penalties that may be applicable to the final marks that you will obtain. And you're allowed to write your memorials or to argue in 4 languages. So you can prepare your memorials in English, in French, in Portuguese, and in Arabic. So if you're from a university that has more than one official language as a language of instruction, you are allowed the free will to choose whichever of those 4 languages you feel comfortable enough to write your memorials in and to make your oral arguments once you move to the oral rounds that will be happening in Kumasi later in the year. But because the African Moot is a collaborative effort among African universities, the judging is also quite peculiar in the sense that most of the judges tend to be faculty of the universities that are participating in the competition. So it is your own professors and lecturers who would be the preliminary judges, sometimes during the competition itself, so that it also allows universities to judge each other's presentations and to provide feedback on how students have performed during the oral presentations. Perhaps Marty can give us a bit of clarification on how it's going to proceed this year. But in my experience in previous years where all the rounds have been physical, it has been the university teachers who are coming with the students who have been the judges, at least in the preliminary rounds. So you've got that, unique nature of that judging panel as well. But in essence, I just wanted to, well, I saw a question about 5,000 words and whether it's for both the applicants and the respondents' memorial. No. So the 5,000 words is for each memorial that you write. So if you're writing the memorial for the applicant, it must not exceed 5,000 words. If you're writing for the respondent, it might not exceed 5,000 words. So that we have sufficiently concise and brief memorials, but also comprehensive enough to be able to make arguments in a cogent way that is sufficiently understandable. So those are the basic rules of the competition, and I hope that we will be able to have questions and answers and interactions subsequent from here. But Marty, I'm going to leave it here, and I will leave the rest to questions and comments.
Thank you so much, Michael. I think you aptly described the African Moot, and I think I'll also just make further contributions right at the end in the interest of time, because we've got so much to go through. So Juliana, the floor is yours to introduce the World Moot.
Thank you so much, Marty. Thank you, Michael, for this. Hello, everyone. Good morning, evening, night, wherever you are. I just want to be sure that everyone can hear me. Okay, no complaints in the chat, so yes, perfect. I have prepared a brief PowerPoint presentation to introduce the World Moot. I'm not sure if it's going to work, but I will try to share my screen now. Can you all see my screen?
Yes, we can.
Yes, thank
Perfect.
you.
Cool.
Yes.
So for this presentation, I'm just going to briefly introduce what is the Nelson Mandela World Moot Court Competition, and briefly some thoughts on how do you start to write your memorials and some tips, very like do's and don'ts. And then I will leave the floor to my colleagues who are going to give you actual tips on how to do it. So first of all, the Nelson Mandela is a world moot court competition. So contrary to the African moot court, it is actually based on a hypothetical judicial body. It is 9 years old now, 15 years old, sorry. It started in 2009. If you decide to compete in this competition, please keep in mind that the teams are very, very small. So the teams are composed only by 2 students, and we highly encourage gender diversity. So usually 1 man and 1 woman, or 2 women, something like this. Contrary to the African moot court, it is actually open to master students. However, if you are like me, a PhD candidate, you are not allowed to compete, unfortunately. If you are a PhD candidate, though, you might be able to go to the Moot as a faculty representative, coaching the team and assisting them researching and writing the memorials. The Nelson Mandela Moot Court is currently run in 3 languages, either English, Spanish, or French, so you can choose the language of your preference. And similarly to the African Moot Court, the teams are supposed to represent both the applicants and the respondents. So you will be required to write both a memorial for the applicants and for the respondents. And during the oral rounds, you will be required both to argue the case for the applicants and for the respondents, depending on the round that you're doing. In this competition, memorials are extremely important. Why? Because we make the selection of the teams based on the memorials. So not everyone that actually wants to participate will get a chance to argue the case orally. Based on the memorials, 50 teams will be selected from the 5 regions of the UN. So there will be a lot of diversity, but only usually the top 10 teams from each region will actually participate in the oral rounds. And just quickly introducing the oral rounds, I know it's not our main point here, but there will be 50 teams participating, and the first stage is going to be online. And then from these 50 teams, the best 24 will actually go to Geneva to present their case orally in Geneva. When it comes to the case, that is very diverse, very different, as I had already mentioned, from the African Moot Court, because we are arguing the case here before a fictional international human rights court. And what does that mean in the end? It means that you are allowed and you're actually expected to use a broad variety of sources to substantiate your arguments. You do not have to get attached to, and you are not actually expected to get attached to only one region or only one instrument. You can actually have a look at all of the sources of international human rights law that you can think about and try to incorporate that in your memorials and in your arguments. So you should go to both regional, national, international instruments, national case law, regional case law, human rights committee cases, advisory opinions. If you find a very good general comment, please bring it in. Declarations that human rights officials might give, like during interviews or during a seminar or something like this. Resolutions, principles, and reports. In any case, almost anything that you find can actually and should be used. We actually encourage you guys to have a look at everything and do not just have a look, for example, to the European system, because it's very easy to find, as I'm pretty sure my colleagues will show you. It has a very easy database, or in case you're very familiar with the African system, please go beyond that. Go to the European system, go to the Inter-American one. If you find any kind of national case law that you consider interesting, please bring it on. Feel free, let your imagination flow and try to find as many sources as you can. That is very, very interesting. And we actually enjoy very much when teams bring in different cases that we never heard before or different sources. Okay, so you decided to participate. Now you understand how you should look for your sources. Now what? When I was doing this Moot some years ago, I'm a former participant, I was very lost. I had never written a memorial before, and I had no idea how to begin to write it. And at the time, I had a really good idea that later on I actually passed on to my colleagues in the university, that was to have a look at previous memorials. The Moot Court team makes them available. The winning memorials are available in the website. Obviously, you're not supposed to copy them. Please do not copy them. But you can have a look at them to understand what exactly were we looking for, like which sources, how many sources and different sources they actually look for, how do they structure their argument, how exactly do they cite their footnotes, how clear are their structures. So you can have a look at these memorials, and I think it's a really interesting start point if you've never mooted before, if you don't even know what a memorial should look like. Have a look. They are available and they can be very, very useful, but do not copy them, please. And then, just as quick tips too, some do's and don'ts in the memorial for the Nelson Mandela. So obviously, let's start with the don'ts. Do not identify your team. You're not supposed to be identifiable either by your university or by your name. We cannot know who you are, so obviously we can ensure fairness. You have to put a summary of your arguments before you actually start proceeding to writing them. It's very useful for the judges to understand what exactly are your main points, where are you starting from, and how are you going to conclude that there was a violation or there was not a violation. So this should go before your actual argument. So don't forget about the summary of your arguments. Please pay attention to the word limit. The memorials here for the Nelson Mandela, they are shorter than the African one. So we actually ask you to keep within 3,000 words, including footnotes. Of course, if you, for some reason, write more than that, we are going to read the memorial still, but there will be some penalties. And if you decide to write less, please make sure you still have all your arguments. Make the best use you can of these 3,000 words. And do not forget to remove revision marks or comments from the document. I know you're going to work in pairs in your team, so we will exchange the memorials many times, many emails, or sometimes it's going to be online. So it is very expected that when you're writing the memorial, you're going to put like some comments for your co-counsel or co-agent, but don't forget to remove them, especially because they might identify you and you cannot be identifiable. And some tips of what you should do. As my colleagues are going to further explain, you should write clearly and obviously stick to your chosen language. Even if you do speak more than one language, please don't write half of the memorial in English and half in Spanish. Stick to your chosen language, write clearly, short sentences, go straight to the point. Do follow the instructions on how to format your memorials. They are on the website, they are on the official rules of the competition. So there is a sequence of everything that you should put in your memorials, the summary of your arguments, the arguments themselves, the table of authorities. So all of this should be there. Follow these rules. Otherwise, again, there might be some penalties. Same thing, follow the instructions on the content of the memorial. Sorry, I mixed it. So the contents of the memorial are on the rules and obviously includes the summary, the table of contents, the table of authority, and the formatting is obviously the font, Arial 12, if I'm not mistaken, but please ensure to read it and to follow them. And the last tip is just to have fun and enjoy, because mooting, especially the Nelson Mandela, is a unique experience. It teaches you so much. And if you end up like being a very excited mooter, you might be actually end up like me, 9 years later, still attached to it, still having a lot of fun, making new connections. And it's a unique experience. Enjoy it as much as you can. And I think that was it from me. If you have any questions, I'll be happy to answer them after all of my colleagues have finished their presentation. Thank you.
Thank you so much, Juliana. A virtual round of applause for you and Michael. I think we're off to a good start, and we've set the framework for the moots that we are speaking about, and I think that will go a long way in even contextualizing the information that's about to be shared. So without further ado and without wasting too much of our time, I'll invite Dr. Sanya, who will then open up and share with us on how to structure legal arguments in the international human rights law system. Sanya, over to you.
Thanks, Matty. Thanks, Juliana and Michael as well. And thank you, Simpiwe, for also organizing. I hope you can hear me and see me. I'm in a place where there's a little bit of background noise, so please bear with me. If at any point you can't hear me, just type out in the chat and I'll see what I can do. There was a question in the chat before I begin. I'm just going to answer that quickly. Anonymity is important so that we don't know which university you're from. So you will be given a team number and you will have to use that team number in your communication with us and as well as in the memorial. So if you look at the rules of the Moot on the website, it tells you where your team number needs to be. So yeah, I'm going to quickly share my screen like Juliana because I've prepared a short presentation. And then I hope you can see my screen. Okay, great, thank you. Okay, so I, like Juliana, have been associated with moot court competitions after participating, coaching, judging. It's just one of those things that if you get into it, it's very difficult to leave because you just love it so much and it's so much fun, which is why, as Juliana said at the very end, don't forget to have fun because that really is, it's like you're having so much fun, you don't realize you're actually learning things. Anyway, I'm going to move on. I'm associated both with the Price Moot Court competition as well as the Mandela Moot. And today I'm going to be talking to you a little bit about memorial writing at the Mandela Moot. So let's start with what you need to do first. So suppose you've never participated in a moot court competition before. I would invite you to read the rules first. So go to the website and click on documents. And then you'll see there are a number of documents and let's have a look at the rules. So rules 6.1 to 6.2 are the most important rules because they set out the formatting rules for the memorials, including what has to go on the cover page. There's even a sample cover page for you to use. Word limits are set out there, style is set out there. And as I've said in bold, anonymity is really important. So you need to use your team number instead of your university. And as Juliana said, obviously, if you flout any of these rules, then there will be penalties. But that, in my view, that's like not a great reason to lose marks on your memorial. So these are quite simple to comply with. So that's why you just start there. And then I would invite you to read the competition case very, very carefully. And if you think you're done, read it again. What I used to do when I participated in moot court competitions was, along with my team members, we would have, well, with the Mandela Moot, it's just one more team member, but we would have facts quizzes. So we would quiz each other on different paragraphs of the facts and what the different parts of the facts said. So that's how closely you need to know the facts, because when you are up against judges and they're asking you questions, the facts are really your best friend. You know them better than anyone else. And don't forget there are clarifications to the facts as well. So it's not just that one document, there's the other document of clarifications, and remember to read that because that clarifies certain important parts of the facts that may have been left out or corrected. And then I would invite you to check the deadline for submissions. Like, again, this is something that you can do really easily. I've pasted it from the rules. It says no later than 1 May 2023. And just for clarity, it's 23:59 SCST. Now, don't wait until the last second because that is when your computer gives up on you. That is when you're going to find it difficult to hit send. You might send it late. My advice is do it in advance. Now that you know that this is the deadline, start by working backwards. Sit down with your team and manage your time well, create a schedule, and try and go through at least 2 drafts before you reach a final memorial. That's just so that you give your draft some time to breathe and then you come back to it, and then your writing then improves because you see things that you didn't see before, etc. And as Juliana said already, read past years' winning memorials for an idea of what you need to produce. It's always helpful to see something that's done and realize that those people also started where you're starting from scratch with an empty Word document. And yeah, you can get your memorial up to that level. But again, as Juliana said, please don't plagiarize because we will know, and that's not nice. No one learns, no one wins, so don't plagiarize. Okay, next. What I've got on your screen here is the memorial scoring sheet. Now, this is something that memorial judges have in front of them when they're reading your memorial, and it's a really good idea for you to look at that sheet because then you need to make sure that you've got all of those things in your memo to get graded on that. So the first thing is case knowledge. So I've already talked about how important the facts are. So knowledge of the facts, which means, look, sometimes the facts are deliberately ambiguous to help both sides make arguments, but don't make things up, please, because we know when you make things up, it's not great. So that's why the next part under case knowledge is correct and accurate analysis of the issues. So what we want you to do is really just go in there, identify the right issues, and then you get points for that. So that's a whole 25 marks. So that's a quarter of your entire mark for the memorial. So that's the first part. Then we move to human rights law knowledge, and Juliana was really helpful. She set out all the different sources that you can look at. I'll be talking a little bit about that, but not in that much detail. So the first thing is familiarity with international authorities. So we want you to consider a whole range of international authorities, not just one or two, but a whole range. And then we want to test your knowledge of international law, because it's an international human rights law moot, but it is an international moot. So we want to know, do you understand how the doctrine of sources works? How are you constructing your argument? What are you using to construct your argument? And then the knowledge of legal principles directly applicable to the facts. So the first subsection, we discussed facts and the correct analysis of that. And then we want to see you use the facts and the legal principles and put them together. So we want to see you applying the law to the facts. So that's the second subsection. So that's already half of your grade for the memorial. Moving then to technical presentation. So I know a lot of people leave this to the very end, but it's again a whole quarter of the grade. And that includes drafting, so style, footnotes, acknowledgement of authorities, typography. So all of those things are things you can very easily do because the rules are so clear about what we expect. And the reason for that is that it's uniform. Everyone has the same thing. No one has an advantage with that. And then the document layout, margins, paragraphs, and word count. So it's really important for you to state your word count. And don't try and lie. We all know how to use Microsoft Word. We can figure it out if you guys are not telling us the truth about how many words your memorial is, your memorials are. So word count is something that you've got to make sure is also there. And then language use. So how accessible is your language? Use short sentences. And I know that with me speaking in this rolling way, I'm using very long sentences. Sorry, I just got distracted by the chat, but I see Matty has responded. So please, you can click on the link that Matty has put in the chat to find out more about the footnoting style, etc. So clear, coherent, and understandable language. And then finally, it's really important to have a bibliography as well. Then we move on to the final quarter of your grade. That's the strength of argumentation. And it's always easier to arrive at a strong argument if you really just take each step seriously and you go through the steps. So the rest of my presentation, I'm going to go through the steps that one would use to construct an argument in international human rights law. So under that, we're looking for substantial argumentation. And that simply means don't just assert your argument. Don't just expect us to believe you if you say in one sentence a particular right is violated or that the state did not fulfill their duty. While that is a helpful and important first sentence, we expect more sentences under that to explain that. And we also expect you to use law to support that claim. And then we're looking also for a little bit of creativity. And that's the other thing. I think that's why all of us stay associated with moots way beyond our participation ages, because we find it really exciting to see what new arguments you're going to come up with, what exciting creative arguments you're going to come up with. So that's the ingenuity bit. But you'll see that's only a small part of one quarter of the whole thing. So, you don't have to, not every argument needs to be like completely knock it out of the park, sort of entirely new argument. It doesn't. Just stick also to the basic arguments. But if you come up with a creative idea, go for it. And then finally, persuasiveness and conviction. So how strongly do you believe that argument? But it's, again, like just using strong words isn't helpful. You've got to show us, you've got to demonstrate that. So there you go. That's the sheet that all the memorial judges will get to judge your memo. And you can see the scoring guide at the bottom as well. I'm going to move quickly on to the next part of this presentation where we discuss where and how to start research and legal argumentation. I'm aware that I'm running out of time, so I'm going to be as quick as possible. Please pay attention to the PowerPoint slides. So the first is write out a summary of facts from each side. So Juliana reminded you not to forget the summary of arguments. You also need to have a summary of facts. And then you can review it at the end. And then that way you know, okay, these are the facts for this side and these are the facts for the other side. That doesn't mean you make up facts. That just means you summarize it from the perspective of applicant and then from the perspective of respondent. Then you find all the international instruments that are mentioned in the case. Now, the Mandela Moot is unique because it uses a lot of different regional and international human rights systems and human rights treaties, but they specify exactly for what point of law you need to look at which treaty. So although the ICCPR and the ICESCR are mentioned for the substantive parts in this year's problem, you also have to look at the African African Convention, and you have to look at the Inter-American Convention as well, because it very specifically specifies where that's relevant. So don't make the mistake of just sticking to the ICCPR and ICESCR. You will not win any points by just sticking to that. Familiarize yourself also with basic textbooks in international human rights. So if you're confused, like you're not really sure what the limits of a particular right are, what is the content, look at these textbooks. They will help you as a starting point. And then they will often have footnotes which you can follow. So like what I often tell teams when I coach them, or when I used to do it, I used to always say follow the footnotes. It's just a really helpful way of researching. And then familiarize yourself with the UHRI database, because you can then use the work of the UN treaty body committees, universal periodic review reports from states, and the special procedures mandate holders. And that's a great database. I mean, when I started my research back in the day, this database didn't exist. And now it does, and it makes my life so much easier. So please, I'm sharing the knowledge, use it. And then familiarize yourself with the doctrine of sources in international law. So look at the ICJ statute, Article 38(1), and that really lists all the different sources in international law, because your moot problem is drafted in a broad way necessarily. All the issues are drafted in a broad way to invite you to consider all the different ways of making the argument as well. So don't forget customary international law. That's also something that could help you. Don't forget treaty interpretation, rules of treaty interpretation in international law. Those will also help you. So like I said, this is also an international law moot. So remember that. And then you split up the issues among your team and get started. Don't waste any time. Just go for it. Now, very quickly, before I hand back to Mati, I'm going to discuss how to structure an international legal argument. Now, the first sort of sorry, guys. Okay, I'm going to continue now. My apologies for that. I'm going to place with a little bit of background noise, so please excuse me. So moving on then to how to structure an international legal argument. The first thing you do when you draft an argument is identify and state the rule. State whether it has been violated or whether it has been fulfilled by the state. Super important. That's what you're arguing. It's the core part of your argument. Then move on to the relevant facts. So what are the relevant facts that you're going to use to back this up? And find the paragraph numbers in the problem. Another important thing, a lot of people don't do that. Then go on to muster your sources to either support the point you've made or to disprove that point that you've made. Sorry, I hear a bit of feedback. I think there might be someone unmuted. So Simpi, if you could please help with that. Thank you. Moving then quickly to the next point. Ask yourself, identify and muster sources. So the first one is you have to prove that a particular rule exists. And that could just be saying it's in this particular provision, in this treaty, or if it's a rule of customary international law, then you'll have to show state practice and opinion juris. Then you have to show application to the fact pattern. How is this rule relevant to our facts? You'll have to show that. Then there are a bunch of questions I've put there to ask yourself. First, do different instruments have different approaches to the same rule? A lot of times you see this with freedom of expression. But there are other areas of law also where there are different approaches that different systems have. Then consider, are there any exceptions to the rule that you are arguing? How does that exception affect the argument at all? And then what is the argument from the other side? And how can this side counter that preemptively? So those are all really important questions to ask yourself when constructing the argument. Then importantly, identify what the consequences are of the rule violation. What are the implications? What happens now that the rule has been violated? And then I will talk a little bit about state responsibility in the next slide. And then importantly, identify the relief that you are seeking. So a lot of times in moot court competitions, we find that participants forget about this part. And this is actually the most important part, because why are you here? And often as oral rounds judges, we have to ask you, why are you here? What do you want from us? And this should be in your memorial. It should be clear what you're looking for. What is your relief? This is my last slide, so I'm going to be quick also. Sorry for taking so much time. So the first thing when I talked about consequences was attribution of that particular set of facts to a state or to a particular person or to a perpetrator, basically, to show that when we're talking about the state, we want to show that the state is responsible. And so the articles of state responsibility or the articles of responsibility or state responsibility for internationally wrongful acts that the ILC adopted in 2001 is publicly available. That is a document you will use to establish attribution. Then I also invite you to focus on state obligations, because really the moot is, of course, it's about rights, but the other side of rights is obligations. It's really, really important for you to explain what those obligations are and how they have either the state has not fulfilled those obligations, etc. And then finally, I want you all to just remember one thing. States can limit rights in certain circumstances. Rights are not absolute, right? And the mood also invites you at some parts to understand the extent to which that limitation can actually take place. I've provided in shorthand on the screen what that limitation looks like, but there's a lot of case law and you'll be familiar with that. If you look at the past year's memorials, you can see how winning memorials have used that to make their argument as well. So that's something to also remember. And that's it. See you all in Geneva, hopefully, and good luck with the competition. I'm going to stop my screen sharing now and hand back over to Mati.
I cannot say thank you enough. I think that everyone can agree that this is quite an engaging and important discussion that we're having, and all the tips that we're sharing. I want to notify everyone that the floor is now open for questions. You're welcome to pose your questions via raising your hand, and I'll acknowledge that, or typing your question in the chat box. It can be directly to me or in the Q&A function as well. So that will help us accept questions in all these different manners. So in my first round of hands, I already have a hand from Samuel Oladipupo and Calvin Churnside, I'd like to believe. Do forgive me, we've got literally words and names from all over the globe, so I may get some wrong. So we'll go first with Samuel, and then second we'll have Calvin, and then I'll take a second round of hands. Samuel, go ahead.
Okay, thank you very much, ma'am. Okay, my question is, first of all, one of the coaches, the presenter, said that the memorial should be about 5,000 words. That's the first man that spoke earlier. I wish sticking to 3,000. And the second line of question is this 3,000 words limit applicant or both the applicant and the respondent? That is what I'm saying, is that should the respondent and the applicant divide the issues and the words to 1,005, then 1,005, or the applicant can take up to 1,005, then respondent can take 1,005, or the applicant can take 3,000 and the respondent can take 3,000. Thank you very much. I may have another question, then I'll raise my hand and do so. Thank you very much.
Great, thank you so much, Samuel. Calvin, if you can also pose your question, and then I will direct the questions to the relevant speakers.
Okay, wonderful. Thank you. Can you hear me?
Yes, we can.
Okay, wonderful. Thanks, Marty. And thanks also Sanya and Juliana for that really insightful presentation. Two questions. The first is whether we can have access to the more recent best memorials, I think from 2020 onwards. And the second question is whether or not the statement of facts are supposed to be the same for both the applicant and respondent memos. Yeah.
Okay. Thank you for those two questions. I will indulge myself and take the first part of that first question posed by Samuel concerning the desire to increase words, but I'll also encourage the speakers to add on to anything I do miss. We need to remember, I just want to give you a bird's eye view of what happens behind the scenes. When you submit all your memorials, we sit down with over hundreds of submissions. And so we ask our judges to judge over hundreds of singular documents that are 5,000 plus. And so this is why this is also a part of the test of the process, that we are also trying to establish how well can you limit your arguments and make them as concise as possible. Remember that there's two legs of the argument, the written arguments as well as the oral arguments, for a purpose. So are you able to really make your arguments as concise as possible and deliver them well? Also, just to be clear as to what Michael was referring to when he spoke about the 5,000 word limit, it is for a singular side. So the applicant's memorials are limited to 5,000 and the respondent's memorials are limited to 5,000. I hope that this makes it a little bit more clear. And I will invite, maybe we can go in the order of Juliana and then Sanya. And Michael, if I believe that you are also here, if you can also maybe just turn on your camera, and then I'll be able to spotlight you each so the speakers can see you all. Thanks.
I think I'm gonna get started. I still don't see Michael though. I am not sure I could hear correctly the first question because my audio was not working properly, but I think the question was related to the word limit, if I'm not mistaken. So in the World Moot and the African Moot, it's the same thing. You have two memorials, one for the applicants and one for the respondent, and each memorial has its limit. So you do not need to split, for example, the Nelson Mandela, you don't need to split the 3,000 words between these two memorials. So the memorial for the applicant should be up to 3,000 words. The memorial for the respondent should be up to 3,000 words. And yes, you can have access to the best memos for the previous years. I'm not sure exactly up until each year they're available, but on the website you can find at least 2 examples that I checked in today. So in the Nelson Mandela, they are available online. You can have a look at them. And I will pass the word to Sanya because I think the rest of the questions are directed to her.
Thanks, Juliana, and thanks to both of the participants for asking questions. Yeah, I just want to second what Juliana said about the first question. I've just pasted in the chat the link to the rules and rule 6.1, which clearly indicates that each memorial, and then it tells you what needs to be in each memorial. So each memorial, the applicant memorial must be 3,000 words and the respondent memorial must be 3,000 words. But this is for the Mandela Moot. This is not for the African Moot. And then with regard to the question about the statement of facts, so what I would invite you to do is consider, so obviously we're saying to you, don't ignore certain facts or don't make up certain facts. But when you look at the facts, you'll see there are certain facts that are helpful to the applicant, and then there are certain facts that are helpful to the respondent. So when you make your summary of facts for the applicant, obviously include the ones that are helpful to the applicant. Don't omit the ones that are unhelpful, but the way you characterize them can be done in a way where they seem, you're obviously taking them at face value, but you're placing more emphasis on the helpful facts. So it's really about the tone with which you write the summary of facts for both sides. I hope that that's helpful. And I hope it's also clear that I'm not asking you to make up facts or ignore facts. I'm just saying the tone with which you write it and the emphasis of the facts will be different for applicant and it will be different for respondent. I'm going to hand back.
Thanks so much, everyone. Michael, unless you have something that you wanted to add on, I will open up for this next round.
And just to confirm that the rules are quite similar for the African Moot as well. The 5,000 words is for each memorial, so it's not something that you're splitting in between the applicant and the respondent. If you're writing a memorial for the applicant, it's 5,000 words. If it is for the respondent, it's 5,000 words. So you don't have to split any of those. But I had a few other comments that I wanted to make, but my internet wasn't so good. make them now before the next round of questions come in. The problem questions are designed in a way to include a lot of irrelevant facts as well. So you must bear that in mind, that one of the skills that is also how to distill what are the essential facts and what are the most important issues that you need to focus your attention on and argue. Because you can get distracted by red herrings that we intentionally put in the problem to see if you're capable of identifying what the most relevant issues are for the purposes of the arguments that you would make. So essential that you address every single conceivable argument that you think you can make, because then you're going to have so many arguments that are very thinly made out that it is not comprehensive enough to make a clear, concise, and legitimate argument. So just keep that in mind, that you would have a problem question for the African Moot, for instance, which is about 15 pages or so long, and a lot of them are facts that are put in there to muddy the waters and to see how best the person who is writing the memorial or is making the argument is capable of distinguishing between which facts are relevant, which ones are just put in there to see it, but also to just be sure that the facts that are most relevant, because there could be 20 cases that you could identify, issues that you could identify from just reading the problem question. So you must be focused and choose quite carefully what you think important issues are. But also in the writing of the memorial itself, just be as clear as possible. There's really no indulge in overexpressive Latinisms and trying to use all the Latin maxims that you've learned in the course of your studies, because with the essence of the memorial writing is also to teach you how to be able to write very clear, simplified English that anyone at all who picks the memorial is capable of reading and understanding and making reasonable sense. And beyond the substance, it is also important in you format the document itself. Things like how headings that guide the reader is quite, can have very long kind of memorials that really is difficult to read because there's no signpost, but specific argument is being made here. Be quite consciously and intentionally clear that you're going to have a lot of significantly quite a number of subheadings that guides the person who is reading and marking the memorial, and it makes it easier and more interesting to read. But it also things like justifying the text so that it's and then it is not everywhere, and these are little things that can be a difference between a memorial that the person wants to read from the beginning to the end and one that may receive someone trying to quickly scan through to see if you've made any kind of relevant argument. Because you must remember that whoever is marking the memorials is a human being. They are not beyond this kind of biases, and it is completely in your own interest to ensure that you don't allow yourself to fall into the disadvantage where, because the memorial is not aligned properly, there are no proper headings and stuff like that, you may find that the person who is marking is not paying as much attention as they should be paying to the memorial. Because I've marked memorials for over 7 years, and I can tell you that sometimes there are some memorials that are extremely difficult to read because there isn't proper headings. The sentences are so long and winding and confusing, and you really are struggling to make sense out of it. Meanwhile, you've got another 80 or so memorials that you need to mark. So you're trying to get through it as quickly as possible. So it's a matter of helping yourself and helping us, so that as clearly and concisely as possible that your memorials are, the better it is for everyone. But otherwise, Marty, you can proceed with the rest of the questions.
Yeah, some really, really important gems you've dropped there, Michael. Thank you so much. I noted a note here that says format for success. So to all the coaches in the room, please train your mooters to format for success. Like Michael said, you want to help the marker want to go through your entire memorial. And I think something that kept coming up from even, I think Sanya mentioned it, that once you get into mooting, you don't get out. It's a bit of a cult. And we're all past mooters here with the fellow presenters, and we've been coaches as well as markers. So we've sat in all the relevant chairs, and it's so important, and I cannot emphasize enough how important it is for you to not only bring your substantive argument, but to dress it well. The same way that you want to dress in your number ones in the court, dress your arguments in their number ones. I see that the second round of hands, which may be my last round of hands because we did schedule to finish at 2:30, and I don't want to keep my my panelists here as though they don't have anywhere else to go. We will have other conversations and other opportunities for engagement. Just on this note, apologies to everyone for having failed to make this clear at the beginning that there will be other rounds of information sessions for the other language groups, specifically for the Spanish language group, for the French language group, as well as the Portuguese language group. So if you are in the room, you are more than welcome to engage in this conversation, but there will also be workshops specifically directed and conducted in those languages to ensure everyone gets as much assistance and as much access to resources as they can. So in this next round of hands that I'm going to take, I acknowledge Regina, I acknowledge Adeline and Erica. I will start with Regina, and then we'll go to Adeline and Erica.
Okay, thank you very much.
Go ahead, Regina.
Okay, please, am I audible? Please, am I audible?
Yes, now you are audible, but if you can move a little closer to your mic, if it is that it's far away from you, just so you're very clear and sharp.
Okay, please, am I audible now?
Yes, much better.
Okay, thank you. Okay, so I have two questions, bordering on one summary and the second question on structure of argument. So the first question, bordering on summary of fact, please, is one allowed to rephrase a fact while kind of summarizing the fact? For instance, changing words, changing statements are kind of while picking out the relevant fact. Asking this question because they are basically ways you put facts and they help you in your argument. Okay, so my second question is on structuring of argument. While writing your argument, I want to know what comes first. Is it the fact, like fact relevant to the argument you want to make on that particular heading before the law, or is it the law first before the fact relating or relevant to or applicable to the particular law you've stated?
Thank you, Regina. I'll take all the questions and I'm noting them. And then we'll have the round of answers. Adeline, you can go next.
Thank you, Mati. I hope I'm audible enough.
Yes, you are.
Thank you. So my question, I think that Regina has addressed it. Mine was just on the summary of facts. Is it that we get to have the same exact replica from the fact sheet when we're making our summary of facts, or can we be able to manipulate them rather to suit our case? Thank you.
Thank you. And Erica, you can go now.
Hi, thank you. Can you hear me? Okay, great. Somewhat similar question to Regina. I wanted to ask about the structure that Sanya raised earlier. Just wanted to ask whether we're expected to really explain the rule or the principle that we're relying on. I'm asking this because when we look at some of the best memorials, I noticed that these are mainly like cited in the footnotes, but they aren't really run through in detail. So we're just wondering, like, what is the expectation for how we explain the rule and then match like the citations. Thank you very much.
All right, thank you, speakers. This is how I will ask my speakers to address the questions. I will ask Juliana to deal with fact manipulation as posed. That was the heart of the two questions that were posed. And then I'll ask Sanya to deal with argument structure in the two phrases that it was posed. Juliana, you can go first.
Thank you, Mati. Thank you for the questions. You are not supposed to simply copy the facts, or at least you don't have to simply copy the facts when you're stating them in the applicant and in the respondent's memorial. Use them as an opportunity for you to kind of manipulate them in a way that you can highlight the most important facts, as Michael has said, both for the applicants and both for the respondents. So obviously, the cases are very long. There are many things that you should consider, but not all of them are super relevant for the applicants and not all of them are super relevant for the respondents. So if there is anything in the case fact that is not very favorable for the respondent, that might improve the case for the applicants, don't cite that, obviously, or don't strengthen that, don't highlight that in the applicant's, in the respondent's memorial, and vice versa. You can also use the facts as a way to try to insert your argument. So if there is any kind of contentious issue, for example, was a speech hate speech or not? Are they refugees or not? Just try to avoid these terms in a way that actually strengthens your argument. If you are a respondent, for example, and you are saying, I'm using case facts not from this year, and if you're saying that you censored their speech because it was hate speech, you are actually going to emphasize that in your case facts. And as applicants, you cannot say no, it was hate speech. So obviously try to use different words. So it's a bit of a work for you to actually highlight the strengths of your argument and what you're focusing on. Of course, manipulate them as respondent and applicants. Don't simply copy and paste them, if that makes sense. And I will leave the floor.
Yes, yes, no, definitely that makes sense. Sanya, you can go ahead right next.
Thanks so much. So of course, that's sort of the explanation I gave before as well. So I completely agree with Juliana about how to use the facts. So I'm currently looking at this year's problem, and there are lots of like screenshots from like quoting specific effectively tweets from particular characters in the problem. And like, for example, I wouldn't rephrase the tweet, obviously. Like if you want to quote the tweet, you quote the tweet directly, but you can say, for example, I'm looking at paragraph 34, Justice Dare Guru is the Chief Justice of the Constitutional Court of VI. And then he tweeted something about this oldie's wisdom is that he whose hands have been in the pepper jar must not touch his eyes. So in my state summary of facts, I might not quote that entire thing, but I can just say the Chief Justice of the Constitutional Court of VI tweeted, and the tweet was received in this way. So you can definitely rephrase. With regard to the argument-based questions, so with the question of what comes first, the law of fact, again, I'm looking at this year's problem, and you can see in paragraph 46, let's say, for example, issue B says VI's arms trade and its treatment of the Varanadian refugees in Drago zone are inconsistent with its international human rights obligations. So that will obviously be the heading, right, of your issue. Now, if you are doing it from the applicant side, then obviously you will be arguing in a particular way. So it says, let us focus is the applicant here. So what you will be arguing is essentially you will have to have a few sentences that talk about the law. So which human rights obligations are you talking about? What are the specific rules? So you'll set that out as well.
but you will obviously refer to VI's arms trade. You'll obviously refer to VI's treatment of Varangian refugees in the Drago zone have violated X provision of Y treaty. So that's how you will start. And then you will go on to substantiate that argument in the format that I suggested. Now, of course, there's a lot of stuff on the internet about how to frame a legal argument. So you're welcome to obviously frame it differently, but the way that I suggested is the way that I usually would coach. As long as you have the law, the facts, the application of the law to the facts, because I showed you on the score sheet, right, that these are things that you evaluate, the evaluation is based on that. That's what matters. Now, moving to the next question with regard to the expectation for to what extent to address the assertions. Of course, take your cue from previous year's memorials, because you'll see that previous year's memorials have made a sort of trade-off in terms of how much to explain and in terms of getting arguments in. So obviously what we don't want to see is like a bullet point list of all the possible arguments that you could make for each thing. We want you to exercise your discretion and choose the strongest argument. We then want you to explain, we want you to actually argue that argument. We don't want to just see an assertion there. It seems to me like if you've already had a look at last year's memorials, you're on the right track. So just bear in mind that however much we are asking you to explain, you also have a word limit of 3,000 words. So of course, it's a bit of a delicate dance that you have to do, but you will get there eventually. You are on the right track. I'll stop there, Mati. You can have the floor again.
Thank you again, Sanya. Thank you, Juliana, as well as Michael, for the great insight that you have provided for all the speakers and the learners in the room. I would love to take another round of questions, but I don't see it as being practical or feasible given the time that we have left. However, I encourage the speakers in the room to go back and rewatch the entire presentation, as sometimes we tend to miss things in the heat of the moment. It will be available on the Center for Human Rights' YouTube page. It is also available on the Center for Human Rights' Facebook page. I will also then make sure that I repost on our different social media platforms where you can find this particular resource. So in that spirit, it is important for you to be following the World Moot and the African Moot on all the social media platforms, on Twitter, on Facebook, and on Instagram. So on Twitter and on Instagram, it's the African Moot or the World Moot. And even if you're not participating in the other Moot, it's always just good to follow each one, so that in the event there's resourceful information such as this session that we just had, you have access to that information. And on Facebook, it is the Christof Heyns African Human Rights Moot Court competition. So it's the name of the competition in its entirety. But if you look up the African Moot, that is the hashtag that we often use, you can find our materials under that hashtag. You're also able to find the World Moot under the Nelson Mandela World Human Rights Moot Court competition. So please engage with us on your different platforms. You know, tag us, use our hashtags, let's get the conversation going, let's keep the conversation going, because beyond our participation in the moots, the desire is to become great legal minds, and great legal minds are created in the library, they are created in the moot court, but more in the library. So I encourage you to keep reading, keep studying essentially towards the various competitions, and to keep your minds open to the experiences that you're about to gain. Anyone who's mooted will tell you that it is not a waste of your time, and it is not a waste of your energy. And something else that's really important that I noted from the caliber of questions that we were getting, please, teams and coaches, I encourage you to sit down with the rules of each competition and to really study them and to know them thoroughly inside out. They really help you address some of the finer details. I have also noted the request for us to update the memorials on the websites. I do apologize that this hadn't been done thus far, but we will endeavor to ensure that the memorials, the past winning memorials, are up to date. And we encourage you once again to continue to register. And in that same vein, I just want to remind you of the important dates that need to be noted. For the African Moot, the close of registration is on the 30th of April. The 30th of April, that's for the African Moot. And for the World Moot, the close of registration is the 1st of May. But the difference in the two competitions is that the African Moot has a separate date for its memorial submission deadline, which is the 15th of June, which gives anyone participating in that moot ample time. Even if you decided to start preparing today, you would have ample time to participate. Whereas with the World Moot, both registration and memorial submission coincide. And so your registration is complete when you submit your memorials. So at the moment, if you have already registered, you have done this in the form of filling in the Google form that is available via a link under the registration tab on the website. And your registration will be complete on the day when you submit your memorials, which is the 1st of May. And as Sanya said earlier on, we are encouraging you and really just pushing you to understand that time is always of the essence. You don't want to have to fight with technology or have to find Mati and email her and try and find her contact numbers to call her and say, please, my dog ate my cable. So let's really work on making our submissions in time. And the memorial markers, if you guys submit the great memorials that they were asking you to submit, will be done by the 15th of May, all things being equal, but they are human. So if this date is not kept true, we ask for your patience in this regard. And the same announcement will be made soon after the 15th of May, and we'll be able to know who will be participating in the online virtual rounds. So everyone, I want to say thank you once again. And I also just want to ask if you have access or are in a position to turn your camera on, for you to turn your camera on so we can get some pictures, as is the work that we do online and virtually. So I'll just give everyone just like a 5-second breather and I'll start taking screenshots. So keep smiling in case you are appearing on my end, and we will be sharing your lovely faces. If you do prefer not that we don't share your faces, we respect your privacy and ask that you inform us or don't turn on your camera. So in 3, 2, 1, start your smiling. All right, I have a few pages to go through, so keep smiling. There we go, lovely smiles. Thank you so much for everyone. I can see you joining in, some of you from your offices, some of you from your homes, and everywhere else. All right. Almost, keep smiling. All right, I think we got everyone's beautiful smiles. And once again, thank you, and really have an amazing rest of your evening or morning, depending on where you're joining us from. And please continue to send in those inquiries and to engage with us. We really are excited for your participation and your success in these competitions. Once again, thank you to the speakers and have a good day, everyone. Bye-bye.